family, our organizers, our speakers, and our participants. We ask for your blessings and divine providence that activities set for this webinar be successful and effective. We humbly ask you to shower our speakers today with your greatest inspiration so that they may share the most of their knowledge, heart, and soul to their respective topics. We pray that you would deepen our comprehension, broaden our thinking, and transform our understanding of what we are about to learn today. We pray that you bless all the committee members of the IPR cell that they may be able to fulfill their task with responsibility and the objectives they have set may all be achieved. May we be a living witness of your genuine love through the implementation of the knowledge acquired through this webinar. Grant us your divine wisdom. We ask this Jesus Christ, our Lord and our Savior. Amen. I now request the B.Ed students to lead us in the worship song.
Bless the Lord, oh my soul, worship His holy name. Sing like never before, oh my soul, I worship Your holy name. The sun comes up, it's a new day dawning. It's time to sing your song again. Whatever may pass and whatever lies before me, let me be singing when the evening comes. Bless the Lord, oh my soul, oh my soul, worship His holy name. Sing like never before, oh my soul, I worship Your holy name. You're rich in love and You're slow to anger. Name is great and Your heart is kind. For all Your goodness I will keep on singing. 10,000 reasons for my heart to find. Bless the Lord, oh my soul, oh my soul, worship His holy name. Sing like never before, oh my soul, I worship Your holy name. And on that day when my strength is failing, the end draws near and my time has come, still my soul will sing Your praise unending. 10,000 years and then forevermore. Bless the Lord, oh my soul, oh my soul, worship His holy name. Sing like never before,
wonderful. Thank you so much, Dr. Carolyn and the students of B.Ed. Now, I would like to invite our principal, Dr. Vinita Prakash, for her opening remarks and inauguration of IP Center at Isabella Thoburn College.
Thank you. On behalf of Isabella Thoburn College, I would like to extend a warm welcome to all the participants who have joined us this afternoon, and particularly Professor K.D. Raju, Dr. Vidisha Garg, and Dr. Shahida Omar, who have accepted our invitation and taken time out from their busy schedules to address the students in this national seminar on intellectual property rights. And it is our privilege and honor that we have the best in the field this afternoon. Professor K.D. Raju, who will be delivering the keynote address, is Professor of Law, Rajiv Gandhi School of Intellectual Property Law at IIT Kharagpur. He has a number of books, chapters, publications, monographs, and projects to his credit. Also a Fulbright scholar, he's the recipient of the Microsoft Young Faculty Fellowship. You will be hearing more about his achievements as he's introduced. So Professor Raju, we are very happy that you are here in our midst, and I'm looking forward to learning from you this afternoon. Also, I would like to welcome on board our very own alumni, Dr. Vidisha Garg and Dr. Shahida Omar. Whenever I welcome our alumni, I always welcome them back. It's as if you're coming back to the college, and it is our privilege that you are living out the motto of the institution we received to give. Many years ago, you were here as students, and today you are here as resource persons. Dr. Vidisha Garg, who is a partner at Anand & Anand, has been actively involved in the field of patents for over 17 years. And she is nominated as the Asia Intellectual Property Expert in Patent Prosecution and Pharma and Biotech. We are so proud of you, Vidisha, for doing what you are doing. Also, Dr. Shahida Omar, who did her graduation from Isabella Thoburn College, is the Patent Officer, Government of India, and works as an examiner of patents and design. She did her PG from Isabella Thoburn College in chemistry. So welcome back, Vidisha and Shahida. The college is so proud of your achievements. I also welcome all the participants who have joined us this afternoon from the faculty and the students from different institutions across the country. And we believe and know that this webinar is going to be a wonderful experience, a learning experience for each one of us, because intellectual property rights and laws are something that are so relevant. And Professor Raju will be speaking about the relevance and scope of intellectual property rights and laws. The World Intellectual Property Organization, WIPO, defines intellectual property as the creation of the mind, such as inventions, literary and artistic works, designs, symbols, names, and images, which need to be protected by law. And how? Through patents, copyright, trademark, trade secrets, and these law innovators and the wider public interest, in order to foster an environment in which creativity and innovation can flourish, and there will be a better collaboration and better funding opportunities. In the last few years, we have seen that India's research output in higher education institutions, particularly universities, has grown between 2013 and 2017. But ironically, it has been found that there has not been much increase in patent applications. In fact, the most number of patent applications are from the different IITs in the country. So the government, especially according to the National Education Policy 2020 and even NAC, they are exploring the possibility of having IPR cells in different institutions of academic learning. Therefore, the academic community needs a higher level of sensitization and exposure to intellectual property rights and laws. And there is a need to develop in-house expertise for IPR. That is why I said the National Education Policy and NAC mandates that centers and cells should be opened in institutions of higher education. It is with this need in mind that the Internal Quality Assurance Cell at Isabella Thoburn College has organized this national seminar on IPR. And we are happy to have on board some of the best experts in the field to educate and enlighten us on the scope, the relevance, the procedures, and the research, particularly with reference to intellectual property rights. So I congratulate all the members of the IQAC team and the Intellectual Property Rights Cell, which we are inaugurating today. And I hope that this webinar will lead us to more active involvement of all the stakeholders, the students, the young faculty especially, who are involved in research, and create an atmosphere at Isabella Thoburn College, which will not only sensitize the faculty of the institution, but will take it forward to include other institutions, particularly in Northern India. So I'm happy that IQAC and IPR have taken this initiative. And I also take this opportunity to inaugurate the IPR cell at Isabella Thoburn College. And I wish you all the best, IQAC as well as IPR cell, all the faculty, the students. This is just the beginning. And the road ahead may be difficult, may be full of obstacles, but together, like I always say, together we can. And we are so happy that our very own alumni are working in this field and doing such good work. So this is an added advantage to us in the learning process. So once again, my best wishes for each one of you for this seminar. I'm looking forward to it as much as you are. All the very best. Thank you so much.
Thank you very much, Dr. Prakash. May I now request Dr. Alfred J. Lawrence to kindly introduce the audience to the theme of the webinar. Dr. Lawrence. Sir, are you there?
Okay. Can you hear me?
Yes, sir, we can hear you.
Okay. Just hang for a second. Can you see my slides? It's not working. No. Just a second.
Slides are visible, sir.
Yes, slide is visible.
Yes, sir. It is visible.
Can you see the slides?
So, not now.
Okay, it was. Okay, can you see the slides now?
Yes, sir. Yes, sir.
Sorry about the technical issue. Like since past 2 years, like we were planning this workshop or seminar. Like the thing is that like we wanted this seminar to be offline, but unfortunately due to COVID thing, we have to do it online. So it is great privilege, as our respected principal has already mentioned, that it is our great privilege to open an IP center in our institute. Well, the term intellectual, like Professor Raju will be explaining very, he's the best teacher I've ever heard about for intellectual property rights. But let me give a glance of it. Intellectual, what do you mean by intellectual? Intellectual refers to something or some creation that is an outcome of our intellect. So if I give you an example, like if we have a book, if we compose a poem, if we write a song, we can have an intellectual right on these small things also. If we are having a SOP in our labs, we can have an intellectual property right for that also. So it is not restricted to only having intellectual property rights for a house or a car, but for small things, even for like a song, even for a recipe, we can have intellectual property rights. So like earlier, it was only related to IP center was only related to research work. If it was a research institute, then people used to think that the scientists used to think that this is for intellectual property right, it's for them. If they are making a capsule, if they are making any formula, they need like copyright for that. They need an intellectual property right for that. But now it is not like that. Even teaching, for small things like teaching, if we are teaching, if we have developed a particular software for teaching, if we have made an SOP, like their intellectual property right is important. So it is, the intellectual property center is not only restrained to the research level, but it is now going to focus on teaching also. So, well, as Dr. Prakash has already said, that in the recent years, like you can see there is a little jump in the growth of IP. Like if you can see that, India is witnessing a growth in research output. However, the number of patents filed annually is very less. Less than what? Less than China, less than USA. Because in the United States of America, if you go to China, like their individual universities or institutes, they are filing a lot of patents. But our universities and our institutes, that they are lacking to register for patents. Well, here in this seminar particularly, we will be answering like a respected keynote speaker, chief guest, and other speakers will be definitely speaking on what is the role of IP in the academic institutions, why is the need of protection, how can the investment of R&D produce best possible. So in this seminar, you will be definitely learning about these queries, what you already have in your mind. Well, as Dr. Prakash has already told, that maximum patents are being filed by IITs. And then the institutes, that private big institutes, they are like Amity University, they are filing the like patents. But us, like what, like in like IT IT college or other universities, we definitely have lot of different academic things we can register on it. Objectives, what will be the objectives? What was the objective behind having an IP center in our institute? It was like to identify and create IP and take research results to next levels, like to identify market opportunities and collaborations, to clarify the ownership, and like that, like for an economic benefit of our institute, we are having this IP center. Then what future plan, like Dr. Rachana will be just sharing with us, like what is her like future plans. But like we will be introducing a IPR degree, or we will be applying for IPR degree for our students. Like we will be organizing a lot of seminars and workshops related to IPR. That is a must thing which NAC tells us. Then we will be definitely exploring career avenues in IP protections. Like definitely, yes, we have a few alumni that are working in this field, but we will be exploring more career avenues for this. Thank you so much.
Thank you so much, Dr. Lawrence. Now, to introduce to our first, Now I would like to call upon Dr. Rachana Mishra to share the relevance and future plans of IP Center at Isabella Thoburn College. Over to you, ma'am.
Thank you, Samya. And once again, very good afternoon to all of you. As Dr. Alfred Lawrence already told so many things
Rachna ma'am, are you there? Dr. Rachna Mishra? I feel there is some technical issue. I would request the audience to just give us a minute to resolve the issue.
Rachna ma'am, can you kindly unmute yourself?
Yes, yes. Okay. I think that was a technical hitch. I lost my connection. So the aim of establishing such centers at institutional level is to protect the interest of the makers. And if that comes with benefit of others, so what is better than that? So the primary object of such centers is that benefit sharing. So keeping this in mind, the IP Center in IT College is established with the aim. Samya, I think please share my slides.
Yes, ma'am.
So the cell is established in IT College to create awareness, to provide guidance to faculty members, research scholars and students on intellectual property rights, which ultimately give them a platform to showcase their skills set in a way of creating something which is novel, useful, and is an innovation. So the significance of intellectual property is a reason as to why such IP centers are important in any institution. So taking a hawk eye view, one can broadly state the significance like its awareness, then collaborative engagements with private sectors, and active college role in entrepreneurship and new ventures like economic development. Even we can renewed interest of our alumni so that they could be roped in for future projects, of course, which strive to enhance student entrepreneurship and the college inventions converted into new products, services, and companies, resulting in new career opportunities too. So next slide, please. So IP in combination with licensing, entrepreneurship results in generation of new products, services, new ventures. That is all for the public good. Next, please. So the inventions are the main ingredient as far as the innovation cycle is concerned, which is simple in understanding and also in application. As Dr. Prakash and Dr. Lawrence also, that the invention eventually results in revenue generation for the economy, and this can be easily understood as the top ranked institution in India are also the top performers in the intellectual property rights. Like for instance, IIT Madras, IIT Bombay, IIT Delhi, IIT Kharagpur, and IIT Kanpur were the top 5 rankers as per National Institutional Ranking Framework in 2016, 17, and 18. It was also observed that they were the top institutions in terms of patent activity too. So this establishes the importance of intellectual property and also give reasons to develop an understanding of the same. So the college IPR cell, Samya, next slide please. So the college IPR cell at ITC will work on the principle of benefit sharing and knowledge and awareness for all. So the following activity can be undertaken by the college via the cell, and these may be the patent filing and copyright, as Dr. Lawrence already mentioned that we are doing so many things at college, like our PhD students and our MSc students in their dissertation, they are developing so many food recipes. They are innovative products, food products. They are developing recipe books. Even they are developing scorecards for assessment methods, which can be applicable to the community, and especially the other departments. They are also working on different assessment tools which are standardized, but we are not patented anything, and we can apply them in the future for the copyright and for the patent. So we can also promote different outreach program centers. We can promote technopreneurs. Then especially we will be able to research monitoring through our plagiarism software. We are striving for the national and international collaborations and linkages. And we will promote our faculty members and research scholars to finely tune their research work and convert into valuable patents. We are also looking for the in-house training for our PG students, and we're hoping that we will provide orientation about IPR for faculties, research scholars, and students. And we also planning to do some periodic events like workshops, seminars, and trainings, and so on. So at the end of the road, we would stand more learned, well-read about our intellectual property rights, thereby fulfilling the objectives of the creation of such a center. Thank you. Thank you so much.
Thank you so much, Dr. Rachna Mishra. Now, moving ahead, I would request Dr. Sonika Rajan to introduce our audience with our chief guest, Professor K.D. Raju, who shall deliver the keynote today. Dr. Rajan?
Thank you, Sanya. Our chief guest today, Professor K.D. Raju, is a man of actions. His list of achievements is so long that 2 minutes is just not enough. Still, the highlights of his illustrious career are more than 8 books, 19 chapters, 30 articles in journals, 8 working papers and monographs, 50 paper presentations, 10 projects, preparation of syllabi of 12 courses, organization of 17 workshops and seminars, and many more. After his PhD in International Trade and Economic Law, he started his career as assistant professor in 2007, and at present, he is the professor of law at IIT Kharagpur. He has held many teaching, research, and administrative positions and has been honored with awards and fellowships such as Microsoft Young Faculty Fellowship, Fulbright Fellowship. Professor Raju is an eminent member of many editorial boards, expert committees, examiner committees, and is the advisory board of journals. With fluency in English, Hindi, Tamil, Malayalam, and such a long list of contributions, he is an asset to any organization. Taking no more time, I request Professor K.D. Raju to share his expertise with us. Over to you, Professor Raju.
Thank you, madam, for the elaborate introduction, and thank you very much for Dr. Alfred for inviting me for this particular conference. And you know that now the session is on, and I have taken 3 hours class in the morning, and then there was a faculty meeting from 1 o'clock to 2 o'clock. So I took only 5 minutes to take my lunch. So thank you once again, because this is our life. Which we and thank you very much once again for organizing this particular program in your college and the occasion of inauguration of the IP Center. And intellectual property is always so one area where I would say that it is a neglected area by any governments. But with the advent of the Constitution of the World Trade Organization in 1995, and India became a founding member, and it compelled them to amend the intellectual property laws of India and to actively participate in the intellectual property protection in India. I would say that, yes, definitely there was intellectual property laws during the British time as well, but the TRIPS commitments made India to be really an intellectual property country. And also now we are definitely protecting all the areas of the intellectual property. So I thought that I will give you a brief introduction of the areas of all intellectual property law. And before discussing what is the really what is intellectual property, what is the objective of it. So if we look into the intellectual property law, what is this intellectual property as such? So here it's many definitions are available. many scholars are defined what is intellectual property. But if you simply, a layman's perspective, if we look into the definition, we can see that it is, the reward for someone's applications mind, someone's creative mind. So the IP also can be of various forms. It can be an invention. It can be a trademark. It can be copyright in the form of books. It can be fillings. It can be trade secrets, and it can be artistic works. But if you look into, very interestingly, the TRIPS agreement is specifically the various types of intellectual property mentioned in the TRIPS agreement is 7 forms. That 7 forms includes patents, trademarks, copyright, geographical indications, industrial designs, and integrated circuits. I have my association with intellectual properties. Actually, I want to take intellectual property rights, this particular topic, for my PhD thesis. But my supervisor told me that there is no scope for intellectual property in India because India is not going to follow the TRIPS agreement. So I was working on one of the WTO agreement anti-dumping for my PhD thesis. And I joined the Rajiv Gandhi School of Intellectual Property Law. From the very beginning, the school started in 2006. So this school is very unique in its nature. Why it is very unique in its nature means, so you can see that this is the only intellectual property law school in the country under the IIT system, which gives LLB honors in intellectual property law and LLM, and we have PhD students as well as a sizable number of PhD students as well. And more unique is we take only BTech students and MSc science students and convert them into lawyers. So basically, we take technocrats and convert them into lawyers, and so that's the unique, the intellectual property school in the country. So now let us come to the intellectual property. So the various types of intellectual property. If we start with the patents, so I will briefly, because of the we can talk for hours and hours. I will briefly give an overview of the different categories of intellectual property and how it is, the need for protection in the country. So people have ideas, so many ideas in the world. But if we look into the number of patents filed, I think Dr. Alfred has already presented some of the data. The largest in the world over, the US is the major of the largest number of patents filed all over the world. Why? If you look into India also, it is the United States that have filed the largest number of applications. It is not the Indians. So we have filings every year, but it is the number of applications, largest number of applications are not filed by Indians. It is by the United States. Why? So we have to look into other countries because we really say that intellectual property is nothing but innovation. So where is innovation in India? Yes, we say that we innovate and we are the top innovators in the world, but actually not. If you look into the United States, followed by the European Union, Japan, and even small countries, very small countries. 2 years back, I have visited South Korea. You see the number of patent applications from the small countries like South Korea. It is, they are third in number. So Japan, other countries. So we are very far behind other countries. So idea can come from any part of the world, but if it is consolidated into intellectual property law, then only you can get economic benefit out of the intellectual property protection. So India, so now it is almost, it is going to be 25 years. India is a part of the TRIPS agreement. So we don't have time. Now we have taken enough time for protecting our intellectual property. I have registered total nine number of geographical indications from Odisha. They're part of a project which is given to IIT Kharagpur by the Odisha government. So the famous Sambalpuri sari is registered as a geographic indication by me and the team, and followed by other agriculture products also we have registered, and the number of beneficiaries are also we have registered, because every state understood that it is, if you are not protecting your intellectual property law, the other people are going to take away your intellectual property. The best example is, so I'm very sure that the expert, the speakers like Vidisha is here, they'll be talking more about the protection of intellectual property. I just want to give a overview of why we should protect intellectual property. So you maybe heard about the Indian basmati rice, the famous Indian basmati rice. Is taken away by a rice truck, an American company, and they named it Somadi. They named basmati as basmati, texmati, and I think there is 16 varieties of names they put it. And they want to sell it, and they patented it, and they want to sell it. So biopiracy is one area where the patent protection is going to prevent. Yeah, we fought the case, and definitely we won the case. But the basic lesson from the basmati case we fought is that if either you protect your intellectual property or others are going to steal it, and they are going to make it their own, and they are going to sue you. They are going to file cases against you. So this is the world. This is the new world. That world is known as the intellectual property law world. So every people can be ideas, but if it is not protected, it is going to be taken away by others. And they will not only protect, and they are going to file cases against you. So if you come to the trademarks, so we can, I think quickly we will see that intellectual property. And let me talk a little bit more about, the patents. So if you look into the patents, because everybody knows patents, and if I'm going to talk about integrated circuits, people may not be knowing about integrated circuits. If you look into the patents, you can see that it is, it is the limited right, and now it is under the TRIPS agreement. It is 20 years. There are 164 WTO member countries. Everybody has to give the same term of protection, that is 20 years all over the world. So, and no country can give 15 years, no country can, give less than 20 years of protection. You can give more years of protection, right? So, if you look into the patents, I was reading the first patent issued in the United States, to one of the person which is known as Samuel Hopkins. He received the patent number 1 in July 31st, 1790, for an improvement in the making of potash and pearl ash by a new apparatus and process. So if you look into the certificate, this is publicly, this first patent certificate is publicly available. So you can see that this is signed by none other than George Washington, that is the President of the United States at that point of time. So and also the patent is not a new concept at all. I was going through some of the the old patents. So the gem clip, the paper clip which we use today, is patented by a Norwegian, Johan Waller, in Germany in 1899. So we think that the paper gem clip is a new product. It is not a new product at all. It is invented and patented in 1899. So you can imagine. So Thomas Alva Edison have 389 patents on lamp and electrical power, 199 on phonograph, 150 patents on telegraph, and 141 on battery, and 34 patents on telephone. 1 person. So as doesn't matter, you may be a school dropout, but you can have a genius. You can have an intellectual property genius. So I'm not going through what can be patented, what cannot be patented. There are subject experts who are going to explain the conditions of patentability and all other things. Otherwise, I will be taking all of their times. So, but if you look into it, it's very interesting to note that which area the patents, most of the patents are, the patented. For example, I was going through the data. Almost 60% of the products are on car, 54% is on lamp products, 42% is on telephone, 22% on TV, 19% on aspirin, 13% on microwave, 7.6% on computer. So this was the data in 1995. This is a business published by the Business Week in 1995. Before, that means exactly the World Trade Organization has came to existence. And now the percentage has gone up like anything. Now the electronic industry, the complete electronic industry, you can say that whether it is a mobile phone or a computer or area, electronic industry completely covers this majority of the patents. So from innovation, once upon a time innovation was in cars, so 60% patent was in car. Now it is gone to the electronics products. So quickly we will go to the trademarks. If you go to the trademark is, the definition says that it is a unique way of identifying a product or service to distinguish it from competitors. So if you can identify whether it is a Pepsi or it is a Coca-Cola, so it says that it's a trademark. And people won't believe if what is the value of trademark. So yesterday I was going through what is the value of this Coca-Cola logo, Coca-Cola trademark. So the Coca-Cola company is saying that it is $60 billion. 60 US billion dollar is the value of only their trademark, not their assets, not their products, only their trademark. I just want to say that this is the beauty of intellectual property. The trademark itself is 60 billion. So their assets, the intellectual property is going to add value to your, is not only intellectual property, is other properties. So it is going to give value to your movable properties. So intellectual property has to be protected, trademark. And if you look into some of the trademark, the disputes, you can see that the distinctive signs, which you can see that whether it is Tata or it is Reliance or Jio, you can easily identify the Indian companies with the trademarks. So I was just done a case study of Sony. Sony, everybody knows that Sony is a company, it is in electronics. So what is the category of cases, or disputes they file against others? So I saw that the Sony company has filed cases against nail polishes. Nail polishes, the name is definitely Sony. So in 1985, they filed a case against another company who put the nail polish name Sony. So the legality of whether you can put the name Sony to another product, I'm very sure that other parliamentarians are going to discuss. So, and other, you see, goggles. Sony filed a case against, the goggle manufacturers, and they filed cases against textile manufacturers, and they filed cases against a series of products. So, because the Sony, the trademark is owned by the Sony Corporation, so they filed cases, number of cases against the others all over the world. So, and definitely they have to, each and every company to protect their trademarks, and trademarks are going to be very valuable. And quickly come to the third category of products. I'm very sure that I will be within time. Geographical indications. I can take, I can talk for, the full day on geographical indications, because it is a topic which is very close to me. So when we are going for registering these particular products, you can see if you want to really want to understand the culture, the tradition of a particular state, then definitely you have to see the documentation of a geographical indication. So geographical indication is, definitely the geographical indication, the Darjeeling tea. So you can see you can see my background. And, I was there in Kerala very recently. I came back day before yesterday. I took a photograph. So you can see these are the tea plantations in Kerala. So Darjeeling tea is in West Bengal. I am in West Bengal. So Darjeeling tea, the first geographical indication registered is from West Bengal. That is Darjeeling tea. Sorry. So Darjeeling tea is the first registered geographical indications in India. So why we registered it? Because the Darjeeling tea is known worldwide. And the tea board says that it is only 10 tons, maximum 10 tons of Darjeeling tea is produced in Darjeeling every year. But tea board found that almost all over the world, there are almost 15 to 16 tons of Darjeeling tea is sold. So where the extra 5 to 6 tons are coming. So these extra 5 to 6 tons of tea is coming from Nairobi, that is from Kenya, from Sri Lanka, from other countries, those who produces, and they sold it in the name of our Darjeeling tea all over the world. So my PowerPoint is not working in this. So otherwise, I don't show these one of the pictures of, and you won't believe in France, one company they import teas from different countries, including India, and they sell this particular tea in the name of Mongoji tea. It's not Darjeeling tea; it is Mongoji tea. Mongoji tea. This Mongoji tea, almost the same logo. So the Darjeeling tea, you can see that the Darjeeling tea logo is like a lady, a tea stick in her hand. So what they did, they come out with the logo also is exactly the same logo. Instead of Darjeeling, it is Mongoji, and the lady's shape has been changed from Indian lady to a Chinese lady, and Chinese lady definitely the figure is different, and they put it name Mongoji tea. So the tea board again has to fight this particular case in the France courts and put a restraint order against that particular company. So why we want to put the Darjeeling tea, this protect. So if you don't protect your products, somebody else is going to, so we call it duplicate, is going to duplicate the product and sell it and get economic benefit out of your products. So you have to protect specific products originating from a specific geographical area. That is geographical indication. So there are 370 geographical indications are filed in India from all over the country, and the number of products. So if you look into the pattern of filings of geographic indications, the southern states are more into the registration of geographical indications. Southern states like Karnataka on the top, Tamil Nadu second, and third is Kerala, and fourth is Andhra, and so on. So if you look into the northeastern countries, northeastern states, they are on the lowest, maybe 1 or 2, and now we're slowly increasing the number of the registrations. So I think I have presented, and some of the famous geographic indications. I have the 370 slides on geographical indications, and which I actually if some occasion gets, definitely I would be happy to present with you. So including all these 370 geographical indications now protected by the government of India, and now there is a awareness campaign is going on by the DAPP, the Ministry of Commerce. So all products are going to be showcased in our post offices very soon. So these indigenous products are going to be available in all post offices, so that the people knows about this intellectual property geographical indication protection. Quickly come to the industrial designs. So industrial designs are, and definitely the main thing, industrial designs. So industrial designs protects overall appearance or the aesthetic figure of that particular design. All its configuration, it can be a pattern, it can be ornamentation, and which is applied to a particular product. So it can be industrial product. So as this design, so now you can see that the car designs and each and every material designs are now registered. Industrial designs are registered. It can be 3D, it can be 2D patterns and lines, and which can be registered as a design. And most of the industrial products are, the products are registered as design. So it is a criteria which you can see, new and original, anything can be decided as a design. And more importantly, if we can see that some of these suits, some of the the Hollywood and Bollywood suits, design, the design wears. So the designers, those who make the apparels, wears. And once upon a time, the famous fashion pack, the loggerheads with for copying certain dress content. That means the famous Bollywood blockbuster Bundy and Bowley, Bundy or Bubbly. The picture, it's related to a garment which is used in that particular movie, Bundy or Bowley. So the total the damages which claimed is 2 crore rupees. So it's the design. If the designer, I would say that the designer clothes. So if whether it is protected by copyright or whether it is protected by the designs, definitely you can charge. So we have registered 4 designs from Odisha, indigenous designs from Odisha in the Kolkata patent office. So designs can also be a very good income for the violations. So if we take into the copyright, as I have 7 or 8 books. So the copyright is with me, and copyright is now become a very hot take. Copyright violations now. So as everybody knows that now there is a plagiarism software. So each and everything which whatever you write, for example, if you are sending an article to a journal, the first thing they do is they put it in the plagiarism journal and plagiarism software, and the software will tell you that what is the percentage of the plagiarism you have done. And if it is more than, usually in India, it is 10%, less than 10%, the article will be rejected. So copyright is also one of the very important area of protection in India. And especially the India, the softwares are only copyrightable, and softwares are not patentable in India unless it is connected with the hardware. So for the protection of the copyright protection have more importance in India than other countries, because the United States software can be patented, but India, it cannot be patented. It can be only copyrighted. So the copyright protection is very important in India. If we look into the integrated circuit layout designs, I'm very sure that this is the technical area where the integrated circuit layout designs are protected under the TRIPS agreement. Even though the economic importance is very less in India, because if you look at countries like China, the layout design, most of the layout designs are prepared by them, and they duplicate it like anything. So wherever the layout design comes. So if we say that why we want to protect, yes, if we want to protect, because otherwise your investments are going to be eroded for commercial purpose. So your Indian investment is going to be taken away by somebody, and they are going to make economic benefit out of these particular products. If we come to the trade secrets, and trade secret is one area where India is not much, developed. Why I said it is not so much developed, because they made specific legislations with regard to patents, trademarks, copyrights, and all other laws except trade secrets. There is no trade secret law in India. In US, there are multiple legislations, and each and every state there are separate legislations for protecting trade secrets. But India, there is no law as such for protecting trade secrets. But we also protect trade secrets through contracts and non-disclosure agreements and other methods. Mostly, it is common law principles are used for protecting the trade secrets. So people used to say that best known trade secret is Coca-Cola. So Coca-Cola, if you look into, Coca-Cola has fought a number of cases against other people, those who try to, taken away, steal their Coca-Cola, the powder, their combination, the secret, the trade secret, which is on that particular powder, the Coca-Cola as such, it's a combination. But you can see number of cases, not only Coca-Cola, it's a rival, Pepsi-Cola also filed. And you can see that both the companies are cooperated each other in some of the cases, because some of the the employees theft happened in Coca-Cola, and they approached Pepsi-Cola for selling that particular combinations, that formulas, and Pepsi-Cola has informed Coca-Cola about this. So there is mutual collaboration also in finding out the trade secret theft in some of the areas. And now the emerging areas which you can find within the copyright is the broadcasting rights. And broadcasting rights, moral rights, I would say that the other rights which we can see, that the literary works, within literary works and musical works, dramatical works. So you can see the other, you can say that other rights, like moral rights, economic rights, performance rights, and others' rights, the musicians' rights, composer rights, translators' rights, cinematographers' rights, photographers' rights. So you can see so many rights within single right of copyright law. So many rights which you can find. You separate people, all these people on some of the rights. And the protection, I think, almost where you take in patent law, it is now uniform 20 years. You take trademark, and it's uniform 10 years, which can be renewed. Geographical indications, it is 10 years. If you take the trademark, the copyright in India, it is very interesting to see that 60 years plus lifetime of the author, 60 years plus lifetime of the author plus 60 years. So the protection of copyright is very long for an author. So all my books, my lifetime plus 60 years, I think probably another generation's lifetime is also, it is protected and nobody can copy it, the permissions. So, and related rights or neighboring rights, which you can see that the performers' rights and the producers of phonograms and broadcasting organizations and other organizations also own specific rights. So I don't want to actually look into the international agreements which cover all these areas. Yes, definitely. I think I'm exceeding the time. I'll just stop within another 1 minute. So the international agreements, there are so many international agreements. The Paris Convention for the Protection of Industrial Property, basically the patent protection. The Berne Convention, which protects literary and artistic works. And most importantly, the latest agreement, TRIPS agreement. So there is a set of agreements and WIPO agreements which protects intellectual property. So the question is, why you want to protect intellectual property, if you ask me. So I'm very sure that if intellectual property protects your creativity, your intellectual rights, so if you don't protect, what will happen? Others are going to steal it, take away, and they are going to make economic benefit out of intellectual property. So very recently, I have offered a NPTEL course on IP and competition law, the interface of intellectual property and competition law in the NPTEL medium. It is running on, it will run next time. If those who are interested, those who can enroll. Even you don't have to, write the exams, so you can enroll it and you can see how the course is, right? So I think I have talked too much on why you should protect intellectual property law. And I once again, wish all the best for the IP cell of Thoburn College. And I'm sure that the discussions by the subject experts today and the exchange of views and will give a boost to the teachings of IPR at the Isabella Thoburn College. So with these words, I have a great pleasure in starting this particular discussion in this particular conference. And I thank the principal of the college and especially Dr. Alfred Lawrence for inviting me to the program. Thank you. I'm happy to answer any of your doubts. Thank you very much.
Thank you so much, Professor K.D. Raju, for sharing such insightful information on the topic. We are really grateful for the time and effort you took to share your thoughts and experience. I would now invite the audience to ask the questions from the speaker by raising their hands via Zoom. So please, those who have questions can raise their hand and we'll take up your questions. I request all the participants, if you have any questions from the speaker, please raise your hand.
Like there is one question, like Zainab Fatima is asking, how can the intellectual property rights help in revenue generation?
Could you please to repeat it?
Yes, sure.
How intellectual property is going to help the next generations?
No.
Correct?
It is how can the intellectual property rights help in revenue generation?
Revenue generation. I told you that if the entire crux of intellectual property is revenue generation. So the patent is not the end. The patenting is only the starting point. If you get the patent, everybody says that, yes, I got the patent. So what you are going to do with it? You get the patent. If you are not going to commercialize it, if you are not going to license it, if you are not going to the market, then you are not going to get, its economic benefit. So, and if you look into India or any other country, you can see that less than 40% of the actual patents are commercialized. So getting a patent is nothing but these. If you are not going for commercialization, if you are not going for licensing, If you're not going to the market, then definitely the economic, I would say that the economic, you are not going to get economic benefit. So licensing of patent is one of the best way to get, licensing is the best way to get, the economic benefit out of, so it can be licensing, can be, multiple licenses which you can give. So licenses are discouraged. Multiple licenses always you can issue, and then definitely you can get the royalties every year. If you look into the IITs, for example, very recently, the Chennai IIT has crossed, 1,000 patents. But if you look into the commercialization, some of the other IITs, I don't want to name anybody, some of the other IITs are making more money. So it is what I want to say that, so we in IIT Kharagpur, I was part of 100 days, 100 patents. We have registered 100 patents within 100 days. So it was an achievement for IIT Kharagpur. So the at that point of the time, who was leading this particular, the initiation, the director at that point of time, he said very clearly, don't stop with taking patents. If you are not able to commercialize it, it is not going to be sustainable. So if it is going to be, if you want to be sustainable, you have to license it. You have to commercialize it each and every. Then only you are going to be economically benefited. I hope that is going to serve the answer.
Thank you so much, sir. Is there any question?
Yes, sir. Thank you so much, sir.
Thank you, Zan, for the question. Any other participant has any question for the speaker?
Like I just like we have muted chat, so therefore like they have not been able to ask the question. Anyways, like Professor K.D. Raju's YouTube lectures are so famous. Like there are n number of lectures like you can see on YouTube from Professor K.D. Raju, and he is like teaching in SWAM also in NPTEL course. So like we have already registered through this, and we are learning from him, and we will be learning in future also. And like once like this COVID system will be gone, then we'll be inviting sir, if you can humbly come to our institute, and that will be wonderful.
It is my privilege to come once I think this corona and other things subside. Definitely, I would be happy to come to the college and definitely, do a one-day workshop on all these areas. So I would be very happy.
And so your effort is empowering the women also. So our institute is a 100% women institute, and women, more women faculty are also there, like more than 95% women faculty are there. So like it is like you are helping us in empowering the women. So like we will be taking your guidance and your help in your future also. Thank you so much, sir.
You're most welcome. Thank you very much for inviting me.
Thank you. Samia, over to you.
Thank you, sir. Now, to move ahead, I would now call Mr. Alex to introduce our second resource person, Dr. Vidisha. Mr. Alex.
Thank you, Samia. Good afternoon, everyone. It's a great pleasure for me to introduce our speaker today, who is going to talk to us about patent and copyright filing procedures in India. Vidisha Garg is a partner at Anand & Anand and has been actively involved in the field of patents for over 17 years now. She joined Anand & Anand in 2004 and became a patent agent the same year. Vidisha represents clients in several pre-grant and post-grant patent opposition matters. Her practice areas also see her engagement in providing opinions and strategies on patent laws in India, drafting of patent specifications, patent searches, validity, patentability, and infringement opinions. Clients rely on her advice on issues relating to protection of national biodiversity. She also gives advices to her clients in respect of IP asset management and IP licensing. Vidisha has been nominated as ASI/AIP expert in patent prosecution and pharma and biotech. Vidisha is a regular speaker in the national and international conferences and seminars such as AIPPI, etc. Committed to spreading IPR awareness and fostering innovation and scientific temper, Vidisha conducts routine workshops, webinars, and certificate courses on IPR for judiciary, enforcement agencies, and also various schools and universities in association with various government and industry bodies. I welcome you, ma'am, to give your valuable speech. Over to ma'am. Over to Vidisha, ma'am.
Yeah. Good afternoon to all my respected teachers, Dr. Charles, Dr. Prakash, Dr. Meenakshi Singh, Dr. Rajan, all the teachers of IT College present here, all the dignitaries, Dr. Raju, and all the students. I am really very happy and overwhelmed for being invited here to talk about IPR. As Dr. Prakash has already told you, I am an alumni of IT College, and it's really a privilege to come back to the college. It's like coming back to the home. I also congratulate the college for starting IPR cell. It's a very, very good step towards empowerment of women students. Not wasting much time, because patent is such a vast topic, and I have been given 30 minutes time, so I'm afraid I don't know how much I will be able to cover. So without wasting any time, I'll start with my topic. However, I will caution all of you that this is a very dry and very boring topic. So, and especially a lecture in the afternoon will be very boring. So, and for many of you, it is a new topic. So in case you do not understand anything, you can stop me and ask your questions as and when you feel like. I'm just sharing my screen. So I'll start with an overview of patent system in India. I have divided the presentation in 3 parts, like introduction of patents, the Indian Patent Office and filing, and the procedure, patent process in India. So we see the patents are like all around us. Every day we come across new products, innovative products. Companies are selling them by saying that it's an improved technology, improved thing. And all these improved technologies are protected by patents, because patents provide monopoly and they provide an edge in the market. So what actually is patents? A patent is a legal right which is granted by the government of any country. So it is a legal right which is provided by the government, and the purpose is to encourage innovation, technical development, and economic prosperity. Patent is a social contract. It's called a social contract between the inventor, the person who has created the IP, and the society. This contract involves that the inventor will disclose his invention, his invention to the public, and in return of the disclosure of the invention, the inventor will be granted a monopoly right for a fixed period of time, and thereafter, once this time period lapses, the technology goes into the public domain. Patent rights are also called negative rights, because they do not give anything to the right holder, but they only provide him a exclusive right to exclude other people from practicing his invention. So it's a negative right. Like other rights under the law are positive rights, patent right or IPR rights, in fact, are all negative rights. Patent rights are territorial rights, because they have their effect only within the territory of the country where they are granted. And patents right and all the IP rights are transferable. Transferable means that you can sell your rights, you can license or rent it out, you can gift these rights, you can donate these rights. So you, like any other tangible property, these are transferable rights. So the patent rights are a social contract between the inventor and the society. Inventor has to disclose his invention. Complete disclosure of the invention has to be there, and in return, the society or the government provides exclusivity for a limited period of time to the inventor. So basically the role of patent system is very important for the growth of an economy. It promotes innovation by rewarding the inventor. Inventor is recognized for his work. It provides it acts as a reward to the innovator or the inventor. It helps in promoting the diffusion of technology and information by publication. Patent system also promote transfer of technology. It provides a competitive edge to the company or the patent right holder, because he has a right over a new developed technology which other people don't have. They cannot use it without his permission. Patent system helps in wealth creation via economic values of the exclusive rights. They also help in promoting access to technology, and it acts as the patent system acts as a self-defense mechanism for the new products. So the patent rights under the Patents Act, which are granted to a patent owner, are the rights to prevent other people. So the definition of the rights which are conferred under the Act are right to prevent other people from making, using, offering for sale, selling, or importing products that infringe their patents. So nobody can use the patented invention without the permission of the patent owner. Advantages and disadvantages of patent system are well known. Advantages are it provides an exclusivity to the patent owner, which helps in enabling the patent owner in getting investments and returns on his investment. The patent rights are the strongest right amongst all the IPR rights. They are very strong and enforceable rights, and they can be enforced through courts of law. They make invention tradable, because patents can be licensed, they can be sold, so they act as tradable commodities also. Disadvantages of having a patent is that you have to reveal your invention, complete invention, to the public. So whatever new you have created, you will have to disclose everything. You cannot keep it as a trade secret. You will have to disclose the entire invention to the public. It is also an expensive process, because patent involves payment of several official fees and government fees at various stages. So it's an expensive process. You have to maintain your patent for 20 years. That also involves cost. The grant of patent is a little bit slow process. It takes 3 to 5 years. So like other right, like trademark, copyright, you can have right very early. They are granted from 6 to 12 to 10 months, but patent rights takes 3 to 5 years in granting. So it's a slow process. Patents are enforceable only after the grant. So till the patent is granted, you have to wait, and during that period, people can start infringement of your patent. So that is a little bit of disadvantage of having a patent. Alternate to patenting can be, you can disclose your invention by publication. You can keep it as a trade secret, or as a secret. You can decide to not to tell it to anybody. Or the third and the last option can be that you do nothing. You have created something, but you are neither publishing nor you are patenting, but you are doing nothing. So every people are aware, your invention is available to people for copying, so they can start copying your invention. This is the disadvantage of doing nothing. Patents are granted for inventions. So invention has been defined under the Patents Act, which means a new product or a process which involves an inventive step and is capable of industrial application. So from the definition of invention, we understand that patents are granted to new product or process. So it has to be either your product or a process is your invention, and it should be new. It should not be known to anybody before you file your application, patent application, and it should involve a inventive process. So the second criteria becomes comes out from this definition is that the invention should involve an inventive step. It should have some technical advantage or it should have some economic advantage. The third criteria which comes out from this definition is capable of industrial application. It means that your invention should be capable of being produced in an industrial process. Therefore, the three essential criteria of patentability are novelty, non-obviousness or involving an inventive step, and industrial applicability. Novelty means that the date on which you are filing your patent application, it should not be in the public domain. Nobody in the public, not a single person, should know about your invention. Should not be known through any publication or any prior use or knowledge. It should not be part of any traditional knowledge. Therefore, nobody should know about your invention till the day you file your patent application. So for example, there's an example. Suppose you are filing your application on first day of January 2018. So your date of filing of your application becomes 1st January 2018. So all the knowledge and information regarding that field of technology is called the state of art. And so everything till 31st December 2017 will be considered as the state of art. So nobody should know about the invention before 1st January 2018. So this is how a date is calculated and the prior art is determined. There are certain conditions where inventions are not considered novel. If your invention was published in any document before the date of filing, your invention will not be considered as novel. If your invention was published in any patent application before the filing of your application, it will not be considered as a novel invention. If your invention is covered in any claim of any other patent application which was filed before your application, it will not be considered as a novel invention. And if your invention is covered by any traditional knowledge, oral or otherwise, a knowledge of any local or indigenous community, your invention will not be considered as novel. So such inventions will not be granted a patent. There are certain exceptions to the rule of novelty. In case the subject matter of your invention is published without the consent of the inventor, somebody has stolen your invention and he publishes the invention without the consent of the inventor. In such case, it is considered as an exceptional situation and novelty is considered. Some inventions require public trials. So such inventions are also exempted from the loss of novelty. Any communication made to the government are also exempted from this rule of novelty. Any display or use in an industrial or other exhibition notified by the government is also exempted. Use of the invention, if somebody has displayed his invention in any exhibition and somebody else who has seen that invention and that person starts using the invention, such use is also exempted. If the inventor reads any paper regarding his invention before the learned society or publishes the invention in the transaction of such society, it is considered as exemption to novelty, and the inventor is given 12 months time to file his invention, and no loss of novelty is considered. So what an inventor should do and what he should not do to safeguard the novelty. No publication of articles should be made before the filing of the application. No press release should be made regarding the product or the inventive product. Papers should not be, posters or etc. should not be read or presented in any conference before you file your patent application. You should not give any lecture or post any in any blog. It means that you should not make any public disclosure of your invention before you file your application. Do not sell any product which involves your invention before you have filed it. So you should make all necessary steps to see that you do not disclose your invention before you file your application. What you should do is always discuss or make disclosure of your invention by signing a non-disclosure agreement. Sign if you want to commercialize or you want to discuss anything about your invention with somebody else. First, sign a non-disclosure agreement or a confidentiality agreement with that person, with that company, and thereafter you disclose the invention and file as early as possible. जितनी जल्दी हो उतने जल्दी आप application file करें. The next criteria, which is very, very important for patentability, is that the invention should have an inventive step or it should not be obvious to a person skilled in the art. So inventive step means any feature of the invention which involves technical advancement as compared to the existing knowledge or economic significance or both, and that makes the invention not obvious to a person skilled in the art. It means that the part of the invention which has a technical advancement over the existing knowledge. So जो part invention का आपने create किया है existing knowledge के above, that is considered as technical advancement, and that should be necessarily there in the invention, or your invention should lead to some economic significance, like you have created a process which is less time consuming, which involves lesser financial requirement, which is cost effective. So either your invention should have a technical advancement or economic significance or both. Mere workshop improvements or modifications are not considered as involving an inventive step, because there is no technical advancement in workshop improvements and modifications. So they are not considered as inventive. When invention is not obvious to a person skilled in the art, in view of the state of art, it is considered as inventive invention. I'm repeatedly using the term person skilled in the art. Person skilled in the art is an imaginary person which is created by the law. It's an imaginary person. This person is a skilled practitioner in that field of technology. He has access to all the entire state of art. He knows everything about that technology. He is aware of general technical knowledge in that field of technology. He is capable of conducting routine experimentation, and he knows everything about that field of technology. The only problem with the person skilled in the art is that he has no imagination. He does not have an imaginative mind, whereas the inventor is one step ahead of the person skilled in the art, because an inventor has imaginative mind. He has inventive ingenuity. He can create new things. By seeing a problem, he can come up with a new thing, whereas a person skilled in the art knows everything, but he cannot create a new thing. The third criteria is industrial applicability, which means that the invention can be made or it can be used in any field of activity, and it can be reproduced as many times as required with the same characteristics in any industrial process. Then there are certain inventions which are exempted from patentability. They are not considered as patentable subject matter, or these are considered as excluded subject matters. These are like any frivolous or frivolous invention or invention which are contrary to the well-established laws of nature. So if somebody says that I have prepared a perpetual motion machine, so this is something which is contrary to the natural law. There is nothing like perpetual motion machine. So such inventions are not considered as patentable inventions. The second is the inventions whose primary or intended use is contrary to public order or morality, or which causes serious prejudice to human, animals, or plants, plant life or health of the environment. So if somebody comes up and says that I have created a machine which will help in robbery, so such invention will not be granted a patent because they are like contrary to public order. They like this machine will be helping in robbery, so it is contrary to public order. So such inventions will not be granted a patent. Inventions which are prejudicial to the health of human beings, animals, or environment as such, they will not be granted a patent. Mere discovery of scientific principles or formulation of abstract theories is not considered as patentable. Also, the living organisms or non-living substances which occur in nature. So if somebody separates some chemical compound from a plant or a tree, so that product will not be considered as a patentable subject matter. However, the process of extraction will be granted a patent, but the compound will not be granted a patent because that was already existing in nature. That was the part of nature already. Mere discovery of a new form of a known substance which does not result in enhancement of known efficacy of that substance, or mere discovery of a new property or new use of a known substance or new use of a known process is not considered as patentable. So if a substance, for example, aspirin is already known substance in it is known already known as an analgesic. So if somebody comes and says that I have found a new use of aspirin for like as a cancer medicine, suppose, so it is a new use of a known substance. So new use will not be allowed until you show enhancement in efficacy of that substance, or new use of a known process will not be allowed if you if the process involves at least one new reactant or it results in a new process. Mere admixtures which result in aggregation of property is not a patentable subject matter. So there has to be some synergistic effect amongst the components of the composition. Then only the compositions or the admixtures are allowed. Mere arrangement or rearrangement or duplication of known devices is not allowed. Any method of agriculture or horticulture is not a patentable subject matter. Any method of treatment, medical, surgical, curative, prophylactic, diagnostic, therapeutic, or any sort of treatment of human beings and animals is not considered as patentable subject matter. Plants and animals as whole or the part thereof are not considered as patentable subject matter, but microorganisms can be patented. Mathematical methods, business methods are not patentable. Computer program per se are not patentable. However, if you couple your computer program or your software with a hardware, so as a system that is patentable. But per se, computer program or software is not patentable. It's a subject matter of copyright. Literary, dramatic, musical, or artistic work, or any aesthetic creation, cinematographic work is not patentable because all these things, literary, dramatic, musical, artistic work, all these things are subject matter of copyright. So you can copyright these things, but there is no patent for these artistic or literary works. Mere schemes or rule or method of performing a mental act or playing games is not patentable subject matter. Presentation of information is not a patentable subject matter. Topography of integrated circuit cannot be patented. And any sort of traditional knowledge is not patentable in India. CSIR has in fact prepared a digital library which covers all the traditional knowledge of India, like Ayurveda, Unani, Yoga, etc. And that has been shared with most of the IP offices of the world. The purpose and the intention is to safeguard the traditional knowledge of India so that it is not patented. Also, the inventions relating to atomic energy are not patentable in India. So the second part of the presentation is about the Indian Patent Office and its branches. So India has 4 patent offices, one each in Delhi, Kolkata, Chennai, and Mumbai, and they cater to the 4 regions of the country. The Mumbai Patent Office caters to the western part, the Delhi caters to the northern Indian region, Chennai to the southern Indian region, and Calcutta to the rest of the country. This is the entire patent process in India. The process starts with the filing of the application, which then follows the publication, then filing of a request for examination. I'll deal with each step subsequently. Then there is a process of patent prosecution where patent application is examined and thereafter it is granted. So basically the stages of patent process involves preliminary patentability search, then the filing of application, then publication of your application, then you file a request for examination, then your application is examined and patent office issues the first examination report, then you file your response and the application is granted, and then you pay the renewal or maintenance fee for the term of the patent. So to start with, the first process is the preliminary search. So before you file your patent application, you are advised to do a preliminary patentability search to check whether your invention is novel, inventive, and it involves an industrial application. So there are some patent free websites like Indian Patent Office website, US Patent Office website, European Patent Office website. So you can check on through these websites. You can also check through various scientific journals and publications whether your invention is novel, it involves an inventive step, and has industrial applicability. Once you have determined that your invention qualifies all the 3 criteria of patentability, you can decide to go ahead and file your application. For the purpose of filing your application, you will be required to write your invention like you write research papers. Similarly, you'll have to write your invention in a techno-legal manner because patents are granted through a process of through a legal process. So you'll have to write your patent specification, details of your invention in a techno-legal manner, and you will have to fully and particularly describe the invention and the best method of performing your invention. So the main headings which are there in a patent specification is that you'll give a title to your invention, then you'll write the background and the general state of art of relating to that area of technology, and you will mention the drawbacks of the existing art or the shortcomings of the existing art. Then you will write the summary and the object of your invention, why you have done this invention. Then you will describe the drawings, you will describe your invention in detail. You will mention the embodiments and the best method of performing your invention. You will provide the illustrative examples also. Then comes the main part, the claim. Claim part is the part of the specification for which you are claiming the monopoly. And you'll also have to provide the drawings and the abstract. Who all are eligible to file a patent application? A patent application can be filed by the true and the first inventor. The person who has done the invention, who has made the invention, can file the application, or his or her legal assignee. Legal assignee may be the employer or the person to whom he has assigned his invention. Also, in case the inventor or the assignee has deceased, his legal representative can file the patent application. In India, the applications will have to be filed according to the jurisdiction. So whatever is your place of business or place of residence, accordingly you'll have to choose the patent office. Like Delhi If you are in the northern region, you'll file application in at Delhi Patent Office. If you are in Chennai or the southern region, then you'll file application at Chennai Patent Office. Accordingly, you'll have to file the application. Once you have prepared your patent specification, you will file your application at the Indian Patent Office. You can file it either online or through either you can file online or you can go at the patent office and submit there in person. India follows a first to file rule. First to file rule means if two people have simultaneously made the same invention, the person who will first file the application will get the right. So it's always advised and it is always important that you, as soon as you have made an invention, do not waste much time and file your application as early as possible. So the documents which are required for filing a patent application is like application form, which is called Form 1, which is available in the at the Patent Office website. You can get from there. Then you have to draft your patent specification, which is called Form 2. Then there have to be drawings. If you are hiring a lawyer or a patent attorney, then you'll have to give him a power of attorney. Then there are certain other forms like Form 3, Form 5, etc., which will have to be filed along with the application. The fee, filing fee or the official fee for filing the patent application is determined on the basis of number of priority, number of pages of the patent specification, number of claims, and the status of the applicant, like are you an individual or a startup or a small entity. So there are different fees for different statuses. Once you have filed your application, for first 18 months, your application will remain in a box, in a black box. No action will be taken in your application. After expiry of 18 months time, then Patent Office will publish your application in their journal, which is published on their website. So till 18 months, nothing will happen in your application. If you think you want an early publication, in that case, you can request for an early publication by paying the official fee, and then the publication will take place early. Once the patent application is published, now it is ready for examination, but examination will not take place until you file a request for examination. So an applicant is given 48 months time from the date of filing to file a request for examination. However, it is always advisable to file a request for examination as early as possible and not to wait for the 48th month, because applications are examined in a serial order of filing request for examination. So the earlier you will file the request, earlier your application will get into the line on the serial order. So once the patent application gets examined, Patent Office issues first office action, or in India we call it first examination report. This office action or the examination report contains lots of objections. Objections are of two types. Some formal objections which relate to the formal requirements, and second and the most important part is the substantive objections which relate to the substantive, which involves substantive objections on the novelty, inventive step, and patentability of the invention. So there are two types of objections in the office action. An applicant is given 6 months time to reply to this, to file a reply of this office action, or you can take a 3 months extension. So total you have 9 months time to prepare a suitable reply to this examination report and file at the Patent Office. The reply should cover all the points as to how your invention is patentable and the objection is not correct. Also, there is a provision of expedited examination in our Act. there are certain conditions. If the applicant fulfills those conditions, they can file a request for expedited examination. All are not important. One of the most important condition which I feel you should know, that if one of the inventor is a female, in that case a request for expedited examination can be filed. Or if the applicant is a government body or relates to some government organization, they can request expedited examination. Or if you have filed an international PCT application and if you have chosen India as an searching authority, you can file a request for expedited examination. As I had just mentioned in my previous slide, first examination report is issued by the patent office after the examination of all the application related documents. The objections are of two types: formal objections and substantive objections. The substantive objection basically relates to novelty. The patent office will cite few documents and will say that in view of these documents, your invention doesn't appear to be novel. Or patent office will cite certain documents and say that if you read these documents, your invention appears to be having no inventive step. So these are such types of substantive objection will be there. Or patent office will say that your invention does not appear to be a patentable invention in view of the exemptions given in the act. So the applicant will be required to rebut these objections, and the applicant will have to show that his invention is novel over the cited documents or involves an inventive step in view of the cited documents. So the applicant will have to rebut all the objections of the patent office. So once the applicant submits his response to the office action, patent office will again re-examine the application, go through the response, again check all the details of the invention, and if they feel that still some objections are pending, they will issue a hearing. They will call the applicant for a hearing, and there will be a personal interview thing. And there you can discuss your invention, explain your invention, and if the controller is satisfied, controller will grant a patent on your application. The patent is granted by the controller anytime once the time period lapses. Once the patent is granted, the grant is again notified in the Patent Office Journal, which is published and in the Patent Office website. And there is a provision of filing a post-grant opposition. Once your patent is granted and it is published in the journal, anybody who is interested in your invention or who feels that this patent has been wrongly granted can file a post-grant opposition within 1 year from the date of publication. So the rights of patentee are basically, in case of a product patent, the exclusive right is provided to prevent any unauthorized person from making, using, offering for sale, selling, or importing the product in India. If the patent is granted for a process, in that case, an exclusive right is granted to prevent unauthorized person from using the process or offering for sale, selling, importing for those purposes the product obtained directly from the process. Product produced by the process is always protected under the Act. The term of patent is 20 years from the date of filing. So patents, the limited period which I had mentioned in my earlier slides is 20 years. So patents are granted from 20 years. Once the patent is granted, you will have to pay the renewal fee each year. And actually the renewal fee needs to be paid from the third year of from the date of filing. So once you have been granted a patent, you can use your patented invention. You have protected your product or processes, so you can commercialize your process on your own. So it will help you in increasing your turnover, your profits, attracting investors. You can license your invention. You can give license, like you can give exclusive licenses, or you can give non-exclusive licenses to more than one people. There can be provisions of cross licensing also. You can block your competitors because you will have the patent right. You can use your invention and your competitors will not be able to use the patented invention. So these are the few ways in which you can use your invention. So this was all about the patent system in India. Do I have a little more time to discuss about copyright, or if I have crossed my time limit, I can stop. I can rest my case here.
Dr. Lawrence? Sir? I think already.
Yeah. That's why I asked you. Yeah. So maybe we can discuss copyright in some other session. We can have a bigger session for copyright. Thank you. If you have any questions, because I do understand it's a very dry and a very boring topic, but still, if you have questions, you can let me know.
Thank you so much, ma'am, for your stimulating speech. And I'm sure your presentation is definitely helpful for our audience.
Yeah.
Now, I would like to invite the audience once again to put up their questions to the speaker. Are there any questions for the speaker? Okay, yes, but we have one question. Vardha, can you please unmute yourself and ask your question?
Yes, ma'am. Good afternoon, everyone. My question is, what is the best way to protect the literary work which is posted online for students to study?
See, the literary work can only be protected through copyright protection and not patents. So, and if something, and literary work is protected even if you do not register it. So a person, if you are able to show that you are the author of that work and you have posted it, you will have the protection.
I hope your question is answered. Are there any more questions from the audience?
There is a question in the chat box. Hemalata is asking, what is the opinion about Creative Commons? Creative Commons.
So Creative Commons will again will be treated as a literary work. So because patent is a subject matter of improvement in technology. If you are making any technical invention, then it is a subject matter of patents. Comments and will become a part of a literary work which will be protected by copyright and not patents.
Thank you, ma'am. Thank you.
Thank you so much, ma'am, for answering to the questions. Now, moving towards the end, our third resource person is Dr. Shahida Umar. To introduce Dr. Umar, I would like to invite Mrs. Anuja Banda.
Thank you so much, ma'am.
Thank you.
Good afternoon, everyone. Now I would introduce the next eminent speaker of the seminar, Dr. Shahida Umar. Dr. Shahida was born and brought up in Lucknow. She completed her bachelor's from Navyuk Kanya PG College and her master's from IT College with 2 university gold medals. Later on, after qualifying the CSIR NET examination, she pursued her interest in research from CSIR, Central Drug Research Institute. The nurturing and progressive scientific environment there motivated and guided her to publish 7 research papers in international repute journals with high impact factor. In the year 2017, she joined the Indian Patent Office under the Department for Promotion of Industry and Internal Trade, Ministry of Commerce and Industry, Government of India, as an examiner of patents and designs and has been working there in varied capacities. I heartily welcome Dr. Shahida to share her expertise with us. Over to you, ma'am. Ma'am, please unmute your mic.
Yeah. Thank you. And I'm having a great time over here, having such a wonderful listening to these kind of discussions because intellectual properties are it is a very vast field, and it is very tough to compile it within such a limited period of time. And I'm really grateful to my teachers for giving me an opportunity to reconnect with my alma mater after so many years, but still it feels fresh listening to and seeing the entire teachers over here, and I'm really happy. So what I'm about to discuss today is about the yeah. It is about the intellectual property right in research and publishing. Now, till now we have discussed about what are intellectual property rights and how they can be protected, what is the procedure. So now let's discuss how the students which are involved in research and research scholars and those which are preparing to go in that field or preparing to publish their work, how it is important to them and how they can find their research to be relevant for patenting or for copyright. Now, as we can say that till now we have heard of our eminent speakers about intellectual property. We have heard that it is a creation of mind. It is when you think of an idea in your mind, it is the beginning of that innovation cycle that starts there. It is intangible. You can have it in your mind. The inventor has it in his mind that about that particular product or that particular work. Then he searches for it. He looks into it if that particular technology is in the market or not, or if he is about to write something, then he starts writing his thoughts. Then he creates it. If it is, you can say, if it is a literary work, then he creates that work. And coming on to further that, if it is a technological product, then he goes into an R&D and that product is being made. After that, that product has to be tested. Means if you are what you have written, what you have brought into a tangible form, now you have to test that product, that whether it is at par to what you expected it to be. So those studies are done, and after that it is plan it to release in the market. Now, whenever you are planning to release something in the market, it is always in your mind, what if happens if I am releasing if I'm releasing that particular product in the market and someone else is capturing it and using it for some other purpose. But the problem is here, it goes in the mind that the copying or forfeiting or reverse engineering. So that are the things that most of the times the inventors don't show their product in the market, but they keep hiding it till they can use it in a better way financially. So for that, intellectual property rights is an important aspect, that whenever you have found something new and to protect it, to keep others away from it, from stealing it, from copying it, then you go for intellectual property. Now, these creations of mind can be of different types. Like if you are creating a product, if you are technologically, the product is very advanced and you are creating a product or a process, then you go for patents. If it is a design, like if it is a pattern, if it is a industrial design or locomotive design or anything, even a shape of a bottle which is have a better grip. So these things comes under designs. Then the logos, like we have heard earlier that the logos are quite they are very of billions of dollars of certain companies. So here we can see that the logos of certain companies like Adidas, even SBI, that inverted key they have. So they are the logos of that particular companies. Then copyright. If you write something, like if you are writing a paper, a research paper, when it is in the written form, it is a copyright. But if that particular the invention or the particular product that you are discussing in that particular paper comes under patent. Like if I've discovered a molecule and I have published that molecule, So that paper in which that research has been published is a copyright, but that molecule, if I can be patented. So when we talk about research and publishing, we are talking about two intellectual properties. The paper is under copyright, the research publication comes under copyright. What you are writing in it is copyright, and that can be the writers, or it can be of the publishing house, if the writer transfers his rights to the publisher. So that research publication comes under copyright, whereas the technology, the research that you have disclosed in that paper, it can be patented. Now, geographical indications. See, like we have heard of Nagpur orange or Kanjivaram sari. When people go to some place, we ask them, okay, that particular thing is famous over there. It has a different taste. It has a different characteristic. Please bring it for me. So that is the geographical indication. Like that particular product has a special characteristic, and that particular characteristic is linked to that place of origin of that product. So that is geographical indication. That is the speciality of that particular area. Like it can be a product, it can be an artwork, anything. Then comes the trade secrets. Now trade secrets are like Maggi masala, or you can have like KFC masala. So they have a different combination, like Coca-Cola masala. So these are the kind of things that have the trade secrets. Means a particular company has a distinct product, and because of that special item, that's what we call a secret ingredient. So that secret ingredient comes under taste secret. And then the semiconductors or integrated circuits. So these are the intellectual properties which are covered, and it comes out of this innovation cycle. And now coming on to the patents, because the patents are the quite important aspect. If we could talk about the research in India and the publishing, they are more focused on patents, because the patent is a technology which we can sell, which we can use. So pharmaceutical industries or the research institutes in India, we all know that the development of a new drug, it takes billions of dollars. It is quite expensive, and it is a very expensive business to go into that. So a drug company takes about 15 to 20 years to develop a molecule and to bring it into the market. So that particular period of time, that particular amount of cost they are putting into it, at the end of the time, they get a single molecule. And if somehow they are not able to protect it and start selling it, then that particular 15 or 20 years which they have spent in that can be gone in within minutes, because that particular tablet, once it is released in the market, it can easily be reverse engineered to find that particular product which is the active ingredient. So before releasing in the market, before saving these kind of such a huge amount of money, they try to protect it. So because of that, intellectual property has become a serious business, not only for the inventors at a small level. Like either one of us can have an idea, we can develop like jugaad, any jugaad product we can have, so we can go for that. Multinational companies have invested a lot of amount of money in those products, so they go for that protection of that money. And after that, it is not only that they have spent such amount of time. See, some of the like diseases, they are like very, very costly, like cancer medicines, or some of the rare disorders which are there, rare genetic disorders. So when they come to a molecule which is potent, which can cure that particular disease, so it takes a lot of money for them. So what they try to patent it, and now once it is patented, they can sell it in the market at their own price. So it has an advantage as well as a disadvantage. The advantage is that the public is getting that drug. Initially there was no drug, now they are getting the drug. The minus point is that they can sell it at their own rate. The cost is high. So it has a pros and cons. Like patenting, it is a luring factor. Like because of the patent, the company can release that drug in the market, and for a particular period of time, like in India, it is for 20 years, they get the protection. For 20 years, they can enjoy the fruit of their labor. They can sell that drug, and after 20 years, that particular drug becomes generic. Now their patent is the Their patenting right is gone, and now that is available in the market for the at the normal price at which it should have been set. So it has a patenting system. It gives the inventor a benefit that okay, he has applied such a huge amount of money, his mind, his he has put up his time into it, so he gets advantage of that. The higher the technology, the more relevant the technology, the greater the benefit. So drug companies, and then they are continuously focusing on the development of new chemical entities and discovery of new property of a known molecule. Like Dr. Garg discussed that aspirin, you cannot say that I found a new property of aspirin and we can patent it. No, it's not that way. A molecule should be new. It should have efficacy, improved efficacy, so that it can be patented. So a new chemical entity is very much welcomed for patenting. But if you are finding that the molecule is already existing and a new use, no, it is not granted in India. India doesn't grant a new use patent or a new property patent for a same substance. Now, most of the applications that we get in chemical field are related to drug and pharmaceuticals. So coming on to I would like to share one of my during my research experiences that this was a molecule which we have developed in our lab. It was a molecule that has 1,10-phenanthroline, and it is a naphthophenanthroline core moiety. So the molecule which was developed in the lab, it showed fluorescence. It was showing a green fluorescence, and visibly it was colorless. But later on, when we did the metal sensing studies, it was found that it was highly selective for iron 3+, and it didn't show any binding with iron 2. So it was highly selective for metal ions. So we were very happy. Okay, we have found something new. We have searched it in the SciFinder, like chemical search database, that in which we can enter the structure of the molecule, and we can find that if that particular molecule has already been reported or not. So if it has been already reported, that it means that the molecule is not novel, that the structure is already reported, it is not novel. But in case if it is reported, if it is not reported, but maybe that in place of CN we can have any other group, so we can say it is novel, that it is the exact molecule is not there, exact pyridine, exact CN, exact BR, the exact structure is not there. That means the molecule is novel, but its derivative is there. Like it can be a different nitrogen derivative, or it can be a different halogen. So that means that the group is not that group is novel, because the exact copy is not there, but it is not inventive. How can we say it is not inventive? Somehow, because the groups have already, like when one can substitute fluoro with chloro with bromo, and so halogens are obvious. If you say that you have bromo, then you can, it is obvious that someone else can put a chloro over there, someone else can put a different halogen over there. So that means the group, the exact molecule is not reported in the literature, but in place of that a derivative is there. So we can say it is novel but not inventive. But to our surprise, when we searched this molecule, we found that entire molecule, the entire moiety was not reported. Means leaving the substituent, even the naphthophenanthroline core moiety, it was not reported. So it was very good. We were very happy. Okay, I was very happy that we have found this kind of thing. And then I talked to my guide about it. And he knew that, okay, we have found something on a structure which has not been reported before. So he told me, so you should go for a patent. Okay, so it was being a researcher, initially you don't know about it. Means I've just completed my MSc, I've passed, I've just came in the research. So for patent, it was a new concept for me altogether. Like any means a postgraduate student, or we are not really much aware about that at that moment of time. So I looked into it. And finally, I found that, okay, a patent has a title, has a description, and then a preliminary study has to be conducted. So we did the preliminary study, binding studies, and we wrote a template of that. And we filed a provisional specification. Now, provisional specification is a text document which involves a title, abstract, and then a description. That description basically involves the background art, a glimpse of the background art, how your technology is advanced, what is the gap between the prior art, what is reported and what you are reporting. So that gap between what is already reported and what you are reporting, that gap describes your technical advancement. Means the wider the gap, the wider is your technical advancement. So we found, okay, so we wrote that particular paper and everything that we had, we put some studies over there and we filed our provisional specification, and that provisional specification was filed in 2014. Later on, since the provisional specification was filed, it means that we have secured our filing date. Means that from that particular date, that molecule is being protected in a way. Not we haven't received our patent yet, but because we have filed it, that means we have made our first entry and we have secured that particular molecule. So what we did, we secured that filing date, we have secured that application, and we filed that application. At least for that point of time, it was not like a patent was granted, but we have filed it, we have secured our filing date. From that, in 2014, then we wrote our publication. This publication was published in 2015, means after securing our filing. Once we have found the application, once we have found the molecule, we did our study, we wrote a simple 2-page or 3-page description with title and a small amount of study we did, and we filed the provisional specification. Now, after filing the provisional specification, we did our detailed studies and everything, and then the detailed studies were published in 2015 in the chemical communication. So after that, it comes the role of complete specification. Now, provisional specification is a way in which you can secure your filing date, and you do not have to do the entire study. Just the basic preliminary study is needed. After the complete specification has been filed, then you can do your detailed study and file the specification. Now, in the complete specification, the important part is the claims. Now, what claims is basically a thing that differentiates between the provisional and the complete specification. And claim is really important. It is the main part. It is the main thing that you have to define, like what you are asking as protection. Here, what we did, what we claimed, like what we wanted to protect was the compound. So, see, in the publishing, you have to focus on in a single molecule or a molecule which is a group or series, but you don't have to go over a wide like 40-50 molecules. Some cases it is needed, but otherwise you can if it is a study based on like this, we had very limited number of molecules and we published it. But when we go for patent, so patent has to have a very broader, or you can say have a scope up to which it can show its technical advancement. So we had to derivatize the molecules thoroughly. We had to prepare a lot of derivatives so that we can secure the boundary, so that we have covered everything in that. We have covered things that are means that can show that particular property. We didn't want to miss any of the derivative of that. So this was the molecule, or you can say the scaffold, which we tried to put or we tried to patent. Filed in that application. So this, you can say that here in the publishing, it is a simple single molecule, but then when after at the time of patenting, we did a broader derivatization, a broader study, and then we filed this. So the major part was our claim 1 was compound having the general formula 1 and the iron chelators. This is my formula 1, which we are claiming. So if the patent will be granted, then this particular formula will be protected. That means this particular compound will be patented if we will get the patent in the future, because we are asking for that. And what will be protected? This particular scaffold having these groups, which we are mentioning over here. So coming after that, this was one thing that we desired. The second thing was a method for fluorescence-based imaging or analysis of cells and or cellular components. This was the entire method. It means we knew that it was showing bioimaging. It was binding with the iron 3 So we knew that it is suitable for the binding purposes. So we first of all we tried to claim that molecule, because that was the molecule which was never been reported in the prior art. So we thought it was a new molecule, new chemical entity. So we first claimed that. The second, the property it was showing, like the method for fluorescence, the property. So we tried to claim that a method of fluorescence imaging. Then third was a method of detecting, estimating peroxides, because we were able to find out that the molecule was able to detect the reactive oxygen species in the solution. So we did this method also we included and everything. And then coming back to the compound. So these are the three methods. But the problem here is that as we have previously, as we have discussed, and later on I came to know when I came in the patent office, that the method of treatment is not granted in India. So what we did later on, we have to remove this method, because method of treatment or diagnostic or prophylactic treatment method is not granted in India. What is granted in India is either as a patent, is either you can have an invention that is a product, or it can be a process. It should be novel. It should never be reported, should not have been reported in the prior art. That means it is novel. And then if see, like my molecule was totally new, so it was novel. And the second criteria is inventive step. Like inventive step means the gap. What is the gap? Like if the molecule, this is the prior art ends over here, your molecule is here. So this gap, how is it important? What is reported in the prior art? That is, prior art is whatever is available in the literature before the date of filing of your application. Once you have filed the application, everything before that becomes the prior art. So we found that gap was wide because our molecule was already novel. So it was inventive because it was never have been reported. So that means the gap is wide enough. If had already been reported, like somehow it's been problem, like it is not novel and everything, then if it is the molecule is novel, that means it is a gap is quite wider. And then we have to see that that how it is different, means if it is novel, then how much difference is it? My molecule was novel, but we have to see how much difference it is. We have crossed the novelty criteria. The second criteria was, if the difference is there, then how much difference is there? Like if there's fluoro, then we have chloro. If that much difference is there, then that is not we considered depending on the future properties or extra beneficial effect or efficacy that the molecule is providing in that case. So in that case, whenever you have to go for that, like patents, so patent is always protected by an act or a set of rules. Or in India, it came for the first time, the first patent was granted in India to an efficient pankha pulling machine in 1856. And that was granted to George Alfred D. Penning. Now, the first patent act, or the sort of patent act, that was called as certain exclusive privileges granted to inventors of new manufacturers. It was granted in 1856, and from 1856 the patent act has been amended a lot of times. Similarly, the patent rules, means the act is enactioned upon, or it is applied in the form of rules. So the rules were also being made in 1972, because the last patent, that the patent act which is still going is the Patent Act of 1970, and the patent rules were made in 1972, which are still being modified till now, till 2019. Now, what is a patent? We have already heard that we have discussed so much. It is a monopoly right which is granted to an inventor or an assignee by the government for a period of 20 years, and it is an exclusive right that provides you the benefit and excluding others. But it is not an absolute right. It is never like patent, once you have granted, no one else can, because patenting is not an absolute right, but there are certain conditions in which there are situations in which government can use that invention, and there are certain provisions for that. So it is not an absolute right. And patent is a territorial right, because there is nothing as like universal patent. It is always like a particular country grant you patent, like a particular molecule or your invention is secured in India. It does not matter. It is not like that it will be patented or protected in America. If India is granting patent, it means your product is secure in India. In India, you have your exclusive right of using it, offering to sale, selling, importing, distributing. But outside India, you don't have that particular right. So you have to apply for different countries for that patent in different, or for that exclusive right in different countries. Now, patent has been granted, or patent, why it is important, as we all know that once you have found something, you always want to share it unless and until it is being copied or it has been reverse engineered. So that is we have heard so much about it, like patent is important for financial purposes and for bringing new technology to the people. Now, invention is novelty and inventive step. See, the state of the art when you are discussing, it can be a particular product is novel or new. It means it shouldn't have been used before, or it should not be available in any form in any other social media or internet, or it should not have been claimed in any particular patent applications, or it should not have been disclosed orally like traditional knowledge, and it should not have been published before, except that if the inventor has published her research article, like someone has published already published her research article, then he has a time frame of 12 months to file the patent. So that is the benefit in case of research purposes. Then we have heard that inventive step like technical advancement involves invention should have a technical advancement over the existing knowledge or economic significance. But the most important thing is that it should not be obvious to a person skilled in the art. Obviousness means if you are combining two documents and you are creating the invention, means you have taken the knowledge from A document, you are taking the knowledge from B document, and you are coming up to C without any technical ingenuity. And the industrial applicability. Now, these are the section 3, which we have already, Dr. Garg has already discussed about it. And now, patent filing in India, initially it was the physical filing, but in July 2007, the patent filing has been made totally online. There is no need to visit the office. You can simply log into the website of IP, Intellectual Property India, and you can file the patent online. Every procedure, everything is online. So you need not to come visit office at any point. And the different jurisdictions have been decided, like for North India, South, West, and the for foreign companies, they are basically based on the address of service, like the patent agents, which they hire for the filing procedure. So for them, the patent agents, they provide the address of service. Then these are the jurisdictions. For like if you are from Uttar Pradesh, then you have to file your patent application in New Delhi. If you are from Maharashtra, it will be Mumbai. And then if it is in South, then Chennai, and the remaining apart from there, it will be in Kolkata. So what are the documents which are required for filing? Like you need a cover letter. There's an application form 1 that has to be filled in duplicate. These all forms are available at the IP India site. And the application form 1 should be filled, and the form 3, which involves that if you have filed this application anywhere outside India, so that detail has to be given in form 3, that foreign filing details. Then proof of right is actually it is needed that if an inventor has transfers his or her rights to an applicant, like a person who is not an inventor, then a proof of right is that it is a kind of an authority which you give to the other person to file the patent for you. So he would be the applicant of that particular patent, he would be the patentee, he will get the patent, but you will be the inventor. Okay, so it will be the inventor who will transfer his rights to the applicant or the other person, and who in turn will be granted the patent. So the fees you have to submit, then the specification, which I've already discussed, you can file a provisional specification, and then within 12 months, you have to file the complete specification with the claims that what you want to protect. Then the invention, the inventorship, that means the applicant declares the name of the inventors, and those have to be mentioned in Form 5, which this, the Form 1, Form 3, Form 2, Form 5. These are the forms which has to be submitted during the procedure of filing of the patent application. Now, abstract, drawing, and the power of authority, that if applicable. These are the pictures of the forms which you have to fill, like the name of the applicant, the inventors, then the title of invention, the address of service correspondence, address of correspondence. It can be your address or it can be your research institute address. Then the priority, it comes in the case of and applications which have first filed the invention in some other countries. If a local Indian is filing the application, then he will or she will not file in the convention, because in that case you have to file that application outside India, then that will be your convention country. Similarly, and the rest of these are the divisional. See, the time is very limited, so I cannot go into these kind of details. And this is the part where the proof of right is given. Like in Form 1, here the inventors have to sign, and this is called as a proof of right. Like the inventors are authorizing the applicant to file the patent application and act as the patent applicant for that. So here the inventors have to be signed in the column 9. Then after that, these are the declarations which you have to select, and we have those which are not applicable in your case, you have to strike it off. And then the details of the number of claims, the number of pages, the total fees you have paid in cash or check or DD, that details have to be filled. So this is the Form 1 of the patent filing. Then coming on to Form 2. Now the Form 2 is the title of invention, and the name of the applicant, the nationality, the address. And if it is a provisional specification, then you have to add this, and you have to add this title and this preamble in the case if it is a complete specification. Now provisional will have this part and complete will have this part, and after that you have to file a description. See, this is the format, but you can file this entire in multiple pages. It is not like you have to fill the description in a single page. It will be a multiple page document. Then these are the claims. This claim will come along only with complete specification. Provisional specification doesn't have to be accompanied with claims. It comes later on with the complete specification when you have completed your studies, and now you are ready to, you have fully understood that what you want to claim. Then the abstract at the last, and then these are the notings. This is a form for Form 18, which you have to file for examination. If you want your application to be examined, then this form has to be filled, where you have to find again the applicant details, the application number, the date of filing, and the title of your invention. So you have to file Form 18, then only your case will be examined and will move forward for the granting process, or whatever the result, depending on the novelty of your case. So the application fees is 1,600, 4,000, 8,000. 1,600 is for natural person, 4,000 is for small entity startup, and 8,000 is for means companies and other than natural person. And these are the for extra pages, like if you have 30 pages, then only you have to pay 1,600. A natural person has to pay only 1,600 if you have 30 pages and 10 claims, and beyond that 160 is the fees for each page extra, and 320 for each claim beyond 10. Now these are the things which we can. So this is the how a patent application is published after 18 years of filing. Patent application, the application number, the publication date, the applicant name, and the title and abstract. This is the way in which a patent application is published after 18 months of filing. So I think we have limited time. See, in the complete specification, you have a title and then a field of invention. What is the prior art? What is reported? What are the drawbacks in the prior art? Then you can compare your prior art with the present invention, and the disclosure have to be given in the summary, with the summary and with the supporting studies which you have conducted. And finally, in the last, you have to give the claims. Like the previously we in the previous slide that I have shown how the claims in case of a molecule can look like. So the important thing is that if you have to file, if you want to examine your application, then request for examination, like Form 18 has to be filled. If Form 18 has not been filled, the examination will not be done and your application will not move forward for the entire procedure. Then request after that, see the Form 18 fees is 4,000 for a natural person, then in the same order 10,000 and 20,000 for companies and other than natural persons. So this is the procedure which we have already seen. So, and these are the site. So these are the sites where you can get an information about the entire, and you can file your application on the at www.ipindia.nic.in. Online application can be filled, and there's no need to physical filing during these times. Okay, so thank you. And if anyone has any question, please feel free.
Thank you, Dr. Umar. I really appreciate the remarks made by you. You had clearly mastered the subject. So with that, we'll go ahead and take some questions. So all the participants are requested to raise your hand. If you have any questions, so please ask. Do we have any questions?
And there is a question in the chat box. How can the value of intellectual property rights have become a subject of great importance in an emerging economy?
See, economy is, first of all, if you are granting a patent in India, then you are promoting technology, because whenever someone comes with an invention or a product which is new and you are protecting that product, that means you are allowing that particular product to come in the market so that the inventor gets the benefit from it and the consumer is getting the benefit of having a newer product. So that is at a smaller level. Similarly, the startups, the small entities, the small scale industries, they are working in the same manner. They are finding something new, getting it patented, then they are releasing it in the market. And because the product is patented, they can sell it for a longer period of time and avoid cheaper copies of that product. Plus the foreign investors when come to India, they get protection, and because of that protection, they make move their market. They have a marketplace in India, because when the product is protected, then the company will they sell the product in India, because once it is protected, they can easily sell the product in India. So
So are there any more questions from the audience? If you have any question, you can raise your hand. Okay, we have a question from Zainab. Zainab, can you please unmute yourself and ask the question?
Ma'am, I just wanted to ask that in today's time, like artisans, can they also get their products patented, like those traditional products that they are involved in making?
the traditional knowledge cannot be patented. You cannot patent a traditional knowledge like what is been available in the traditional folklore. That traditional knowledge we cannot patent, but anything other than that, if it is new and if it is technologically new, then it can be patented.
Thank you,
I have answered your question.
It looks like we have covered all the questions. Thank you, Dr. Umar, once again for answering to all the questions.
Thank you.
It was a really great session, and you shared some very grateful information with our audience. Now, for the closing remarks, I would like to invite Dr. Meenakshi Singh. Ma'am, please conclude the session with a vote of thanks.
Thank you, Simon, for coordinating the session so well. A very warm good evening to all present here. On behalf of IQAC and the IPR cell of Isabella Thoburn College, I take this opportunity to acknowledge the hard work put in by the organizing committee to organize this one-day national seminar on intellectual property right on work platform. The main IQAC and IPR cell is to spread awareness among the academicians, students, and research scholars about the intellectual property right, not only to the students within the campus, but to our neighboring colleges within and outside Lucknow. I'm very grateful to our chief guest, Professor K.D. Raju, for accepting our invitation and gracing the program by his presence, taking time out of his busy schedule to be amongst us, enlightening us with his immense knowledge. Thank you, sir. Our alma have always made us proud, and today it gives me an immense pleasure to thank our invited speakers of the Dr. Vidisha Garg and Dr. Shahida Umar. Both are our proud alumna. Welcome back. We are very proud of your success and achievements. Dr. Vidisha, you have enriched our participants through your very informative and interesting presentation about patent filing in India. And Dr. Shahida, you have sensitized the young minds through your excellent presentation. And I'm sure the participants must have been benefited and been able to learn a lot from all the three presentations. I thank both of you for being here, accepting our invitation, and sharing your expertise with the participants. We look forward to many more such interactions in near future. I wish to express my sincere gratitude to Dr. E.S. Charles, President, Isabella Thoburn College, and Dr. V. Prakash, Principal, Isabella Thoburn College, for their constant support, guidance, and encouragement. Last but not the least, I would especially like to thank all the participants, as it was your presence and your keen interest which has made this webinar possible. Thank you, the members of the organizing committee, for your hard work. Dr. Alfred Lawrence, Coordinator IQAC Cell, Dr. Rachna Mishra, Coordinator IPR Cell, Dr. Sonika Rajan, Dr. Caroline Begg, Dr. P. Alex, Ms. Samia Farooq, and Ms. Anuja Barla. The link for the feedback form has already been shared, and you all are requested to kindly fill the form. E-certificates will be issued only after your feedback form has been received. You will be receiving your certificates within 7 days via the email. Thank you for being with us this evening. Thank you all.
Thank you, ma'am. Thank you, Dr. Meenakshi.
Thank you.
So, Samia, any last comments?
Yes, sir. So I would like to thank all the participants once again for being with us and for listening to all the three speakers and getting some information from them. So thank you all for being with us. And thank you, sir. Thank you, ma'am.
Thank you, Samia, and God bless you. Bye-bye.